Uh, the name you have on the case and who I am, it's two different people.
You want to smile about it and laugh about it? Take him back.
Laugh.
We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. I'm not threatening you. Say one more word and that's contempt. 30 days. 30 days.
All right, everyone. Today we're looking at one of the most heated courtroom moments you'll see. In this case, a man claiming to be a sovereign citizen shows an extremely arrogant and disrespectful attitude. Throughout the hearing, he constantly interrupts and refuses to stay quiet. His behavior almost makes it seem like he wants to end up in jail. Each time he tries to challenge the judge quickly shuts down his arguments. People who follow the sovereign citizen belief often act as if the law does not apply to them.
Be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue at last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
But that approach simply does not work inside a courtroom. Share your thoughts about this situation in the comments. And if you enjoy videos like this, make sure to like and subscribe so you don't miss future content. Let's take a closer look at what happens next. That moment was fast. One thing that stands out is how calmly and firmly Judge Simpson deals with these situations. He focuses on the facts and does not entertain nonsense. It raises an interesting question, though. What do people like this expect will happen when they act this way in court?
What's your name?
my name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days!
The man in this case seems to treat the situation like a joke, even laughing and smiling during the hearing. The strange part is that this strategy has never succeeded in court. That's why the whole idea behind this movement is confusing to many people. If anyone understands why individuals continue to follow this path despite the outcomes, feel free to explain in the comments. Now let's see what happens when he appears before the judge again. And just like that, things go downhill for him again. The judge gives him a clear chance to respond properly.
Recalls case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1 And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges.
I'll have a
Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration, a $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor, punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I've tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
So first of all, watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a cess cuvee trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
You're
You will
presuming that
you will
jurisdiction
learn
is
how
granted.
to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30.
But he wastes the opportunity. Because of his behavior, the judge holds him in contempt and orders 30 days in custody. Honestly, it's hard to understand what he expected would happen. When someone ignores basic courtroom rules, consequences are almost guaranteed. What do you think his goal was here? Share your thoughts below. Now let's move on to the next part of the hearing. At this point, do you think 30 days was enough, or should the penalty have been even longer? Some people might argue that his final comments pushed things too far. Still, you have to admit that he walked into the courtroom fully committed to his beliefs, even though they clearly worked against him. This situation is a good reminder of how important it is to behave properly in court. Judges have the authority to maintain order, and showing disrespect rarely helps anyone's case. If anything, this moment highlights why it's important to truly understand the law and your rights, rather than relying on incorrect information. Watching Judge Simpson manage the situation was both frustrating and satisfying at the same time. He stayed calm, asked clear questions, and handled the hearing with control. Not every judge deals with these situations the same way, but his approach here was firm and direct. Now it's your turn. What do you think about this case? Was 30 days an appropriate consequence, or should it have been more? Let me know in the comments. And if you'd like to see more videos like this, don't forget to like and subscribe. Thanks for watching and take care.